A unanimous decision handed down by the Supreme Court today rules on the side of an Ohio woman in a reverse discrimination case. Marlene Ames had worked for the Ohio Department of Youth Services for more than 20 years. She contends that she was passed over for promotion and then demoted because she was heterosexual. Her attorney, Edward Gilbert, joins me here now to talk about how the Supreme Court reached its decision in this case. Thank you for taking the time.
Sure. Thank you for having us.
Yes. So in this case, the lower courts in Ohio ruled against Ames, claiming that she did not show a pattern of discrimination. So how did the Supreme Court reach the decision that she doesn't have to present that burden of proof?
Well, this is called a background circumstances. She is a heterosexual, which means that she's a majority person. And in reverse discrimination cases, the Court of Appeals and the Sixth Circuit Federal Court has always ruled that not only do you have to show a basic case, but you also have to show another hurdle, which is called background circumstances. And we've always thought that was wrong and inappropriate. And the court took our case, U.S. Supreme Court took our case and decided unanimously that having groups, a majority group, so-called reverse discrimination cases, having to prove background circumstances is simply not adequate and not appropriate, and ruled our way on this.
And based on this decision, which is making headlines today, how are you able to move forward with your client in this case?
Well, the court remanded the case, reversed basically, and remanded it back to the U.S. District Court in Columbus, and with instructions to follow the law and follow the standard prima facie evidence for a basic case. So we're looking forward to being able to prove our case in the trial court.
Now, Justice Ketanji Brown Jackson, she wrote that civil rights laws draws no distinction between members of majority and minority groups. How might this ruling then open up the door for more reverse discrimination lawsuits? Do you think this could set a precedent?
No. I do not think it's going to set a precedent of more cases. It'll set a precedent in terms of the elements for discrimination cases, but in terms of it being a floodgate of new cases, I think you'll find that's not the case. And the reason why I say that is in our research and preparation for the arguments here, the research clearly showed that 2/3 of the country already did not recognize this in the other circuits. A number of other circuits did not recognize background circumstances as an additional element. They thought it was unfair, so it hasn't changed for them at all. And in those particular jurisdictions, the number of cases have not increased at all. In fact, they've gone down. And keep in mind that you're still going to have to prove your basic elements of a case. It's just that the background circumstances will not be one of the elements that you'd have to jump through that hoop in order to prove a case. But statistics have shown that that's not going to occur. And also, discrimination cases are tough. They're tough to win on basic elements. And so those basic elements are still going to be there. You have to prove your case. So we don't feel that that's going to change very much at all.
Yeah, and are you representing other similar cases in Ohio that might be affected? Because you say these are tough to prove, but are there other ones in court?
Oh, yeah, sure. I mean, there's that's what we do in my practice. But at any rate, I mean, it's one of those situations where it doesn't matter. In this case, she was heterosexual and was discriminated against in favor of homosexuals. But whether it's that particular group or white, black, whatever, that's not the issue. The issue is whether there is discrimination based upon the standard process of what we call prima facie case. That's what the issue is. Mm-hmm. So we don't feel that there's going to be a lot of new cases being found under this new theory. It's just now it's the law all the way across the country, and that's what this case stands for.
All right. Well, thank you so much for taking the time to join us to explain what happened here. Attorney Gilbert, appreciate you joining us at 5.
Thank you for having me.